Okay, I can tell you guys that just as a chief, because I am involved with all of the judges and trying to deal with issues that are court-wide. I can tell you that since the Falcone case decision came out from the appellate courts, that there has been some confusion, and some of the judges have applied that a little bit different than others. All right, versus this is defendant's request to accuse. So are you Mr.?
Yes, Your Honor.
Okay, so you're the one that did the motion and affidavit requesting Department of Reassignment.
Yes, Your Honor.
Okay, and who do we have on Zoom?
Good morning, Your Honor. Hannah Rogers, bar number 16615 on behalf of, and I have Ms. with me here today.
Okay, thank you. I have looked at it, but if there's anything else you want to tell me,
I appreciate that Your Honor is fully briefed on the matter. You saw my reply then?
I did.
Okay. The only thing that I'd like to articulate is that I've been going through this uphill battle for the last 8 months, and these everything that's occurred, the continuances have been completely prejudicial to my case. I've had to excuse 2 witnesses based on not my inability.
Let me interrupt you just for a second, because one of the main issues in this case is media access. I don't know if there's somebody from the media here or on Zoom. Generally, when we're dealing with disqualification motions, issues regarding the kids and their personal information, stuff like that doesn't come up. So I would just caution you guys to not bring that kind of stuff up in case there's somebody on. Okay.
Right. So yeah, I'm not going to get into the substantial issues, just a broad overview. I think that the affidavit clarifies some of my concerns of actual bias, but I don't think it offers anything regarding the appearance of fairness, because the motion, I couched as a motion intentionally to give plaintiff due process on this issue. I think that the affidavit addresses NRS 1.230 and as the cause of action, but I don't think it addresses the NCJC 2.11 side. And my argument is based on just the perception's been painted at this point. There was the order that was granted, and then subsequent to that, there was the April 9th dicta, which I found very concerning. And to the extent that the affidavit clarifies some of those issues, my concerns remain. And I think the perception's been painted at this point. Additionally, we just completed briefing in the Nevada Supreme Court case that for her petition to close or to restrict the access. And in her reply, it's apparent that she agrees with me that we both came to the same conclusion regarding the dicta in the April 9th order. And that conclusion was that the court seemed to at some point have formed an opinion that regarding public access that was antithetical to my position. And I think that when you look at the facts and circumstances and totality of this case, I think that a reasonable observer with the considerations of the guarantees of due process under the 4th Amendment and an impartial judiciary, I think that a reasonable observer, knowing those facts and circumstances, would come to the conclusion that a fair hearing is not likely in my situation. And I say that with all due respect to the presiding judge. He's treated me with honor and integrity. I think that his personal opinion, as he put it forward on the public record in that April 9th order, in this case that is otherwise submerged under NRS 125-110, to the extent that his affidavit offers clarifying statements regarding actual bias, I think that what's actually viewable to the public is going to be the remaining statement. Well, the April 9th order, the affidavit's not going to enter into that because it's not going to be seen. My concerns remain. regarding all of that. And unless the court has any other questions, I'll yield the rest of my time to.
Okay. Is there a response? This was
Yes,
filed as a
Your Honor.
motion, so I do allow the other side to chime in if you want to.
We appreciate that, Your Honor. Thank you. And essentially, our position is that the court's dicta that it expressed and clarified later in its affidavit did not in any way hinder its ability to follow and in line with Nevada Supreme Court law in Falcone. Any personal considerations that the court made in highlighting the friction currently between parties' privacy interests and the opportunities of the public to access public court hearings was highlighted, but then the court said, and I think this is the most important portion, is that personal feelings must be put aside. And that's exactly what the court did when it denied almost the entirety of the court has not demonstrated the level of impropriety or bias that is necessary in order to justify disqualification in this case. In Kirksey v. State, the Nevada Supreme Court case of 1996, basis for bias is when partiality displays a deep-seated favoritism or antagonism that would make fair judgment impossible. And with all due respect, defendant has not been able to demonstrate such impossibility here. And I will yield the rest of our time unless the court has any clarifying questions and needs me to further elaborate on anything that was put in the pleading.
Thank you.
Can I reply to that, Your Honor?
Sure.
Regarding the dicta not hindering, it's not only the dicta, it's the subsequent action of the stay on the day of trial, which again, I'm not going to get into substantive issues regarding the prejudice that was created there, but it's obvious that whenever you have discovery completed and then there's an attempt to build time away from that evidence is going to arguably become stale or cold. And now with the pending writ petition and the contingency that the judge put in the minute order, that we're not going to get resolution on this underlying 19-month-old case until that resolution is, or until until disposition. And I think it's like 300 to 400 days on average to get disposition. It's not an expedited writ petition. So there's the appearance that it was acted upon. It's not just the underlying reasons why, but there was the stay at the day of trial due to the media request, and then there was the continuance on the day of trial and the subsequent stay with a writ petition that had not been filed. It doesn't appear that it was read on the merits, and that wasn't addressed in the affidavit as well. Regarding the statement about personal feelings having to be set aside, I appreciate that again, but I think that the subsequent actions that were taken to continue the matter of an already very old case, I think that degrades that argument completely. And to counter her Kirk's case argument, I would highlight the Williams v. Pennsylvania Supreme Court case, which is more along the lines of NCJC 211. With the indulgence of the court can be begged while I pull up the case so I can cite it properly. But it was in my reply. So Williams v. Pennsylvania, 136 Supreme Court, 1899, 2016, before the United States Supreme Court, it said, bias is easy to attribute to others, but difficult to discern in oneself. And to establish an enforceable and workable framework, the court precedents apply an objective standard that in the usual case avoids having to determine whether actual bias is present. So, and the part that I highlight is that the court asks not whether a judge harbors actual or subjective bias, but instead whether as an objective manner, the average judge in his position is likely to be neutral, or whether there's an unconstitutional potential for bias. That's all in my reply. And I think that degrades the argument regarding the Kirk's case, because again, it hinges on the NCJC 2.11 issue, the appearance of bias being the standard. And again, I just want to underline that the appearance is is that it's not just the dicta, it was acted upon. There was action taken to continue this matter out as far as it is. And now it's we don't know when it's gonna resolve. So it appears that the potential is still there, and it's more than just arguable because action was taken.
So let me just ask both sides. My understanding is that this is in front of the Supreme Court on the writ petition currently, and one of the issues before the Supreme Court is whether or not the case should be reassigned to a different judge. So do I even have jurisdiction to rule?
I think that respectfully, I think that you do, Your Honor, because in the order directing response, which I attached as an exhibit, I can pull it up right now. I have it on a digital version, but I don't have it in my binder here. But the specific sentence that they said was that it said, basically they cited the Valley case. And I can, do you want me to get the order direct response?
You don't need.
Yeah, it said that it wasn't warranted. It seemed to indicate it wasn't warranted. A reassignment wasn't warranted at that level at the Supreme Court, but they signaled that a motion needs to be filed below first pursuant to the Valley case, because we have an emergency writ petition. A writ petition in itself is an extraordinary circumstance. The emergency nature of that. So we have an extraordinary of the extraordinary, and I'm just asking for reassignment on remand. It hasn't been remanded yet. And I concede that issue that she brought up in her briefing, but I don't think it's necessary. I think the principles are still guiding the Montrose factors that I discussed. I think those principles are still guiding. And I think the Nevada Supreme Court saw that, and they put a comma, however, statement, see Valley versus 8th Judicial District Court. They cited the Valley case, which is where I pulled a lot of my legal argument from. And I understand I'm not a lawyer, but I've done a lot of research on these issues because they are extremely important to myself and my children. Based on the facts and circumstances of the case. But
Right. I'm looking at the order now. As petitioner has not demonstrated the reassignment to a different judge is warranted, however, Sea Valley Health System, real party and interest need not address that issue. So they're basically saying they're not going to rule on that.
Yes, Your Honor. And then the subsequent, the however statement, the Sea Valley was highlighting the what I just briefed. And the important part there is absent a motion below. And as soon as I read that order, it informed me that, okay, now I need to, instead of jumping the chain of command, so to speak, I need to put the petition forward to Your Honor to give you the chance to address the issue first.
Okay, I can tell you guys that just as a chief, because I am involved with all of the judges and trying to deal with issues that are court-wide, I can tell you that since the Falcone case decision came out from the appellate courts, that there has been some confusion, and some of the judges have applied that a little bit different than others, partially because they use the word proceedings, and they don't use the word hearings or documents. And there's some confusion about whether or not proceedings includes both, or if they're just referring to hearings. So I haven't gone back and looked at the hearing or anything that you referenced when your judge made a comment, but I know that there is some confusion. I know that the court was involved and asked for rehearing before the appellate court. And that was denied. So they're not going to give us any additional guidance on what they meant by proceeding. So unfortunately, I think we're going to have a little bit of some judges that believe that proceedings mean one thing, some believe it means a different thing. And there are some discrepancies as far as how different case types are treated under that decision. But I don't know that necessarily is dispositive of whether or not the judge was biased or not in this case. I want to go back and look at it in a little bit more detail, and I'll get you guys a written decision, okay?
Okay, thank you very much, Your Honor.
Appreciate your time. Have a good day.
Do you have an expectation as to when we might expect that written order?
I'm hoping within the next week and a half.
Okay, thank you so much. I appreciate it.
Thanks, guys.
Thank you.
Thank you.